The murder indictment against Somerville, South Carolina jeweler Michael Colluci has been quashed. He was set to go to trial this week. That was the big story we expected to report on. But our Jennifer Wood has sat down with attorney Lauren Taylor to discuss the surprise turn of events in this case. Also, the fallout from South Carolina Representative R.J. May's indictment. I'll be sitting down with Andrew Fancher, our investigative reporter, to discuss what he's learned as he's had time to comb through the federal filings we discussed at length last week. I'm Dylan Nolan. I'll be hosting today's episode while Will Folks, our founding editor, is enjoying vacation. Let's get into Jennifer's conversation with Lauren.
We've got a lot to unpack this week with the Michael Colluci hearing, and helping us break it all down is attorney Lauren Taylor, someone who knows her way around a courtroom and isn't afraid to speak about how the system works. Lauren runs Lauren Taylor Law in South Carolina. She handles everything from criminal law, family law. You do civil law too, right, Lauren?
We do personal injury, yes.
Okay, perfect.
So everything you need, and estate planning.
So it's kind of an all-purpose law firm. She's amazing. She's been keeping a close eye on some of the biggest legal bombshells this week, including the judge's decision to toss out the murder indictment against Michael Colluci. So, Lauren, you've been watching some of the state's most complex legal cases unfold, most notably the recent dramatic move by Circuit Court Judge Roger Young to quash the indictment, the murder indictment against Michael Colluci, a Somerville jeweler accused of killing his wife in 2015. The judge dismissed the case this week without prejudice, and we'll talk about what that means. But he cited critical exculpatory evidence withheld by SLED and prosecutors, namely about Sarah Colluci's mental health struggles, her substance abuse use, and a specific suicidal statement she made to her mother just weeks before her death. So prosecutors allege that Colluci staged this hanging with a garden hose, but the defense says that these newly disclosed documents, which were disclosed just before trial was about to start, showed that Sarah had talked to her mother about hanging herself in the days before her death. And the defense attorneys, rightfully so, agreed that this information, or said that this information could have significantly influenced both the grand jury and the trial jury. And the judge agreed, and he found that the omission was a foul with harm, and ordered that the prosecution begin anew and bring this entire case in front of a grand jury again. So it was a really wild courtroom moment, but I guess let's start with the basics. So this motion was a motion to dismiss the indictment, and it was filed under Brady versus Maryland. And most people know this as that you hear the word Brady violation. So they were claiming that there was a Brady violation. So can you break down what that is and why it's such a serious issue in the justice system?
Absolutely. So Brady versus Maryland is one of the foundational cases that is like criminal law 101, we would say. So basically the point of Brady is, if the government is alleging that you have committed a certain number of offenses that violate the laws, then they have to be able to present all the evidence that they have involving the case, specifically exculpatory evidence, which is a fancy word for saying if there's any evidence that indicates that the person did not commit these crimes that the police or law enforcement have come across during the course of their investigation, they're still obligated to turn that evidence over, whether it's favorable to their argument in their case or whether it's unfavorable. So in this specific instance, I think the state was arguing that, there had already been things in the first trial that came out about Mrs. Colluci's mental health. It was certainly referenced in the beginning of the trial. So their argument is the more of the no harm, no foul. And I think that's what Judge Young was referencing. However, it is really important to know what the makeup of that first jury was, okay? From everything that my sources have told me, that there was a significant amount of the jurors that were voting already in the not guilty verdict. So with that evidence and, with the statement of Mrs. Moore, Sarah's mother, that could have very easily pushed any of those other jurors that were still, not convinced into a not guilty verdict, which, would have solved the case back then instead of, letting it drag out to today's current events. So that's one thing to consider too. Now, when Judge Young uses the words no harm, no foul. So when we're talking about prosecutorial misconduct here, a lot of things are going to happen. I think we've seen some things in the Murdaugh case that happened that were truly not Creighton Waters' fault. But nonetheless, they were still falling under that misconduct umbrella where we have to come back and analyze, was this conduct harmless? And if it was harmless, what was the reaction to it? So what Judge Young referenced in that statement was really that the pathologists, other expert witnesses no longer had the benefit of having this information fresh in their brains when they were investigating this case 10 years ago, with the information that Sarah had made statements to her mother that she was going to commit suicide, not just commit suicide, but by hanging, which of course was the method that the defense is claiming that was the inevitable result. So with that being said, I think it's important to say, that the experts didn't have the benefit of the doubt of having this information when they should have had it. So therefore, the argument is that this whole case has been flawed from the very beginning, right? That's why when he says he's dismissing it without prejudice, that means that the state is free to file again. He did encourage them to be much more specific in their grand jury filings, and to really think about this case before they put it forward. I do think that there were some things that happened on Tuesday. I was personally out of town and was getting ready to dive into this thinking we had a couple weeks to cover this trial. But I think some of the evidence and some of the witnesses that were called sped this along a little bit, let's say.
Yeah,
one of them being the former prosecutor.
Yeah, that was, the hearing was really interesting. The former prosecutor that was the lead prosecutor 10 years or when this was trialed originally in 2018 took the stand, and she was so combative with the defense. I mean, the judge even threatened to hold her in contempt.
I think you can even see the face of the prosecutor in the side view I was watching on court TV, and he is kind of like visibly uncomfortable with the exchange. I don't know if she had a bad day, if her child was sick the night before. I would love to give her all of the grace in the world, but that was a very shocking performance that she put on, and it certainly did not bode well for the Attorney General's office. It certainly did not bode well for her professionalism amongst the bar. I think that would definitely have taken a hit just by, I think the first question asked was her name, and it was right from there.
It was right from the get-go.
And Judge Young was very quick to, I think if I had ever been in a position where a judge had threatened to hold me in contempt of court, I would have immediately changed my tune and kind of recoiled that back. But it was an interesting strategy on her part. And, I think when you try these cases, people get so emotionally involved. It becomes part of your life, right? Whether you're a defense attorney or prosecution, when you're coming home at night, you're talking to your spouse about it, you're thinking about it every minute of the day, new things are coming. So you do get attached to it. And of course, she wants to defend her office and all the hard work that they did put into putting this case together. But at the end of the day, this isn't a situation where there's a murderer that is on the loose, possibly. If it is not Mr. Colluci, then it is, in fact, Mrs. Colluci committed suicide.
Right.
So I think that is a different perspective to something like Alex Murdaugh, where if it wasn't Alex Murdaugh, Paul and Maggie Murdaugh did not commit suicide. There is another person on the loose that could be a threat to the public. And so, that also adds another layer to, are you putting an innocent man in prison, not just an innocent man, but a man that there was no crime ever committed?
Right.
And I think that plays a little bit differently into Judge Young's assessment of it too, because you have to prove beyond a reasonable doubt. And if you can't get there and you were playing with some tricks, then you're certainly not going to get there when the rules are being upheld. So
Right.
I think what he did yesterday was absolutely necessary for the state of South Carolina to rebuild our reputation nationally. That, we've had a lot of things happen in our court system down here that is kind of a black eye on our state. So anytime you see someone in a position like his that is, chastising the state and saying, we hold you as a community to a better standard and we demand more from you, I think that helps quell the public's general distrust of the legal system in the state right now.
Right. And, it's been 10 years. I mean, going back to that testimony, it's a long time for people to, remember things. And her mother had to take the stand and kind of recall her conversation with the lead investigator. And it was interesting, what she recalled and what she didn't recall. She couldn't remember if David Owen had taken notes, but she remembered
Kool-Aid.
Right. Remember that her husband had served him grape Kool-Aid. It was really interesting that it has been this long and people, memories fade. Her father has since died. It's just an interesting dynamic and watching.
It's always hard to get justice the longer cases drag on. You have witnesses that have passed away. You have experts that have passed away or are no longer available. So it's already a difficult case for the state just because of the time that has elapsed since the incident to now. But now with the withholding of the evidence, and what I thought was actually interesting and a good move by the defense was to put up Miss Moore's testimony from the previous trial, and to really go into the analysis of the former prosecutor's cross-examination, or I'm sorry, direct testimony, direct questioning of her. So that was really interesting to me because, the prosecutor's argument that she was really just trying to tailor her questions to prevent a hearsay objection, I think that was false. And it was really powerful to bring back the video and see how many times she kept saying, no, don't say what she said. Don't say what she said. And it was a tight line for her to have to answer. And the judge knows better than anyone how to read through that and what intentionality or lack of intentionality might have been in her intentional questions.
I always find it interesting watching attorneys during trial. They're always kind of walking that line when they're questioning witnesses. And that's why, people are always like, well, why didn't they ask them that? I'm like, well, this is why, that could have drawn a hearsay.
It absolutely is. And as far as her memory, it is interesting that over the time period, she was the mother of the victim. So people would think that, she either would believe that her daughter committed suicide or she would believe that Stephen Colluci murdered her. And those things, I think, get a little hazy in her testimony. But I think at the end of the day, the prosecutor did herself no favors by how she answered the defense attorney's questions. It certainly seemed as though she was being a little bit combative, had a defensive attitude as far as what her intent was behind those things. And Kenley and I actually went to law school together, and I think she did an amazing job on behalf of the Attorney General's office. She obviously inherited this case. So, she did the best she could with what she had, and she even preserved the record even further by adding in another additional text message. So I think, not every person in the Attorney General's office is to blame here. I think it's kind of an unfortunate situation, but I do think it's really relevant that a lot of these people are involved in the same cases. And that's an issue that we really need to take an introspective look through SLED, through our judicial system, and see why do we keep seeing the same names in problematic situations within the South Carolina legal system.
Right, because, SLED agent David Owen was also the lead investigator on the Murdaugh case. When he took the stand during the trial, there were a lot of questions about what he presented to the grand jury. And did he lie to the grand jury in that? I think that really, the state had a strong case. It was circumstantial, but they did have a strong case. But I do think that was a moment during the trial where their case didn't seem nearly as strong as people thought it was.
I
Um,
would agree. And I think you have to have these people that are investigating these crimes. They have to like walk and operate with the utmost level of integrity. Because if it's not from the very beginning, the prosecutors are like standing there with one leg, or one arm. They don't know everything. They're relying on the facts that these officers provide to them. So if we have a problem in the investigative unit in our state and these officers are not able to fully and unbiasedly conduct investigations, then of course our Attorney General's office is going to be handicapped every step of the way because they're not getting the correct information that they need to make these decisions on who they indict and who they prosecute. So it's a ground up issue, it appears to be, the more we keep seeing these same names appear.
right. And, in terms of so when you're a defense attorney and you get this, get discovery handed over to you, that's a lot to go through, right?
Absolutely. It's in, Andy Savage's office has had this file. I can't imagine how big it is. I'm sure it takes up at least a room or two in his office. So you're constantly having it updated, right? Like as new things are presented to you. So this should have been caught, especially, with it being the person that it was, the mother of the victim. You would think that this information would have been discovered before now, but 10 years is a really, really long time to not fully turn over your file. You can supplement every single week if you need to, but to not provide that evidence to the defense when the crux of the defense is that she committed suicide, it certainly doesn't come from a clean hands approach from the state.
Right. So speaking of Murdaugh, do you expect his legal team to seize on this ruling in Colluci to bolster their argument for prosecutorial or investigative misconduct in their appeal?
I mean, I wouldn't put anything past Dick and Jim. I think they're great lawyers and they're really creative with language and they take every opportunity that they can to like add another brick in the wall that they're building. I think that it's still the strongest issue with Murdaugh is obviously Becky Hill and her direct infiltration with the jurors there. But, it doesn't look good.
Right.
And I think everyone is just really tired of our judicial system having another issue. Like, we need to be out of the news. We need to not be the state that is famous for, messing up murder trials or, not getting things across the line and playing by the book. So I think that is certainly going to be on the Supreme Court's mind when they're, contemplating this appeal. Is it something that they take a Judge Young's perspective where he even said, look, if they had presented this evidence and we had ruled on it properly in a motion in limine at the first trial and I had allowed it in, it would have probably still survived an appeal. Okay. But he is the judge now. So he said the buck stops here. I am not okay with that. I am not letting that go forward. With more justices that take that type of approach, then yeah, the Supreme Court could say, look, it wasn't easy. We still think he did it, but we need to retry this case to procedurally, protect the things that we hold dear in this country and our constitutional rights and our freedoms. We cannot let elected or state employees, put their hands into investigations and act outside of the scope of their duties. Those people need to be held responsible, and we do need to make sure that justice is done properly, as much as it's annoying and costly, unfortunately.
Do you anticipate them bringing this to a grand jury again to try to get another indictment? Do you think?
Oh my goodness.
Wow, that was a cliffhanger. Yeah, I know. I cut the interview right before the all-important question of whether Colluci will face a new trial in Lauren Taylor's eyes. The answer to that and much more can be seen in the full interview, which is going to be dropping early next week. Also in the full interview, the pair discussed the Karen Read trial. Of course, the Karen Read trial has been the talk of the nation, airing on Court TV this week. A very controversial case from my home state of Massachusetts. So if you're interested in that, make sure that you check out the full conversation when it drops early next week. Now for my conversation with Andrew Fancher about RJ May. So I'm joined again by Andrew Fancher to discuss RJ May. Last week we did a 45-minute show which solely discussed this topic.
Right.
There's now been a week for the dust to settle, a week which you've spent hours researching the details of everything in those horrific filings we discussed last week. But you've also prepared a new news piece, which is great in that it's kind of the first piece that has this comprehensive timeline that runs
Hmm.
through everything that's happened in this case. And then it gets into some new investigatory stuff that you've pulled this week. Can we start by running through the case, just kind of giving that comprehensive timeline for folks who might not be completely aware of what's going on here?
Of course, so to introduce for those who did not check out last week's episode, which I highly encourage, we are talking, of course, about suspended House Representative R.J. May, Robert John May III, who a one of the most conservative lawmakers within the South Carolina House, a former vice chairman, co founder of the South Carolina Freedom Caucus. And for those who are unfamiliar with what that is, and perhaps you could provide more context on this as well, it's essentially a conservative insurgency within the Republican House, consistently at odds, going against the grain with the Republican majority, and a faction that has established a great deal of enemies along the way. That statement fueling a great deal of conspiracy related to the charges as well as the alleged crimes that the feds have accused RJ of committing. Last Wednesday, I watched as RJ May was taken into custody by an armada of state and federal agents, individuals, plain dressed agents with tactical vests, reading South Carolina Law Enforcement Division and Homeland Security investigations, double cuffing the barrel chested Republican, transporting him to the Lexington County Detention Center, conveniently a detention center overseen by one of RJ's former clients, because, as we're well aware, he is also a political consultant, owner of Ivory Tusk Consulting, who Jay Kuhn, Lexington County Sheriff, was previously a client of.
So we've got the arrest, but this comes after months of investigation. You were also at RJ's house when the federal search warrant was served. We got tipped off that there was something going on down there, and you headed over. But it was months between the service of this federal search warrant and RJ's arrest. We've gotten a little bit better of a look into the timeline of what the feds allege was done on RJ's phone, what they discovered when they
Mm-hmm.
took all that evidence. Can you talk a little bit about what the feds took and what they actually cite as evidence in the documents filed against RJ?
Sure. Before we get into that, if you don't mind, let's talk about that 10-month period, because RJ May, and correct me if I'm wrong, but I believe the dangerous place to be at the State House ground was between RJ May and a camera prior to his house getting searched by federal agents. I mean, this man was no stranger to reporters, to press, to answering his phone, and I love a political and public servant who answers his phone, which he did for me on many occasions. Um, Suddenly go radio silent on August 5th, 2024, the day his home again is searched by federal agents accompanied by SLED, who took some 30 storage devices from his house. Although, as we later learned, DHS, Department of Homeland Security, was only interested in two of those devices. More so, they honed in on just two of those devices. So RJ May goes radio silent, only communicating with a handful of mainstream journalists, as we later uncovered. Um, to his credit, attending every day of the 2025 legislative session. That was prior to essentially breezing through a re-election for his third term over District 88, Lexington County, retaining full custody of his children, and then, of course, the ball dropped on June 11th, the 1 year anniversary of both him and his Freedom Caucus allies securing what founding editor FITSNews Will Folks described as a pivotal Republican primary. It's almost a Greek tragedy.
Yeah, I mean, you couldn't write a story better like this if you tried from the perspective of the downfall of the Freedom Caucus. I've spoken with some folks that are
Hmm.
familiar with the caucus's operations, familiar with the GOP caucus as well, and it should be noted that RJ, of course, has fallen to scandal, but Freedom Caucus Representative Adam Morgan ran against William Timmons up there in the upstate, ran for Congress. He ultimately lost, but RJ was kind of, they kind of had a yin and yang relationship within the Freedom Caucus, where Adam was this charismatic, bright, kind of like he could try to sell even within the caucus their own members on sticking together and acting cohesively, or he could kind of go and make the case for their viewpoints publicly in a positive manner. RJ is your classic bulldog, as they like to call
Right.
people down. He's the bulldog politician who could go on the negative and attack people. But when you had the two of them operating in the House at the same time, it was a very powerful pair. And the Freedom Caucus not only lost RJ to this, but they also lost Adam to seeking higher office. Of course, Adam's still very much so in the political game, and it'll be interesting to see what he does going forward. But from the perspective of the politics, it kind of heightened the situation here for the Freedom Caucus this session because they lost two of their leaders, really their two co-leaders.
And speaking on that leadership, I mean, we might as well talk about how the remaining members of the Freedom Caucus handled this RJ May issue. You see, here at FITSNews, we were not only reporting on the extent of what the feds were looking into, we were receiving intimate detail that later turned out to be exactly accurate relating to the username that RJ was purportedly operating under on Kick, which was Joe Biden 69, spelt with 4 N's, I believe, about trips to South America to engage in extramarital affairs with prostitutes. All of this was trickling in. It was being spoken well outside the federal wire, yet the Freedom Caucus soft-pedaled any and all questions relating to RJ. Jordan Pace, in a press conference that you attended, where the South Carolina Freedom Caucus was rolling out their legislative agenda for 2025, he not only essentially refused to answer questions about RJ, he asked multiple reporters, "Why are you asking about RJ?" And whether this was in response to Pace's bombing of that press conference or not, you had another party member, Josiah Magnuson, take to Facebook saying that, yes, RJ is a duly elected representative and he will remain a member of the caucus until or if the man is indicted. Come the day of his arrest, to the Freedom Caucus's credit, they put out a statement ahead of any formal charges being announced saying that he had not, actively participated in Freedom Caucus activities since his house was raided by DHS. Isn't that right? So definitely some issues in the communication, the handling of the RJ May issue. But alas, here we are now.
Here we are now, and here RJ was in federal court last week, and you were in court, and you got to get, an exclusive look in that. Cameras aren't allowed in federal court, and we had people commenting last week like, why couldn't they bring cameras in? It's not just us; it's every federal court in the country. A lot of states they will allow, like South Carolina, have pretty good rules about letting media into courts. Federal courts are not that way. And I don't know that there's even something afoot to change that. But as it stands, that's why the only thing you'll see out of a trial like the Diddy trial, which is a federal trial, are sketches of him sitting in court. It's the same thing with RJ. I'm sure somebody, when this thing goes to the real trial, if it does go to trial, will hire a sketch artist to come in there and do that. But that's all you're going to get. You're not going to get any audio recordings.
No.
So that's why somebody like yourself who was in the room, it's really important to get to ask the questions of what did you make of RJ's defense?
Of course, the defense, RJ being represented by Columbia Attorney Dwayne Phillips. According to attorneys who I've spoken to following that hearing, unprepared. You see, in this detention hearing, which was essentially to determine if the sitting lawmaker was going to get bond, something that they elected to have that day when they could have extended it out 5 days, revealed all manner of graphic, explicit, disgusting detail regarding what RJ was purportedly doing over a mere 5-day period on a social media application called Kick. We had one witness take the stand during the lawmaker's detention hearing. Homeland Security Special Agent Britton Lorenzen, who, again, just laid out in detail how we got to this point, as well as the 260 plus videos pulled from that Joe Biden 69 Kick account, reading off some of the conversations that Joe Biden 69 apparently had with an indeterminate number of like-minded pedophiles, as the U.S. Attorney's Office later put it, over this 5-day period that the crimes allegedly occurred, which would have been between late March, essentially starting Easter Sunday. All right, they're accusing May of starting Easter Sunday, 2024, to April 4th, 2024, mere 5-day period, sending nearly 300 videos depicting CSAM over 400 times, sending some 1,140 messages to like-minded pedophiles. It's as if RJ is being accused of waking up one day, knowing exactly where to go on Kick, an account registered the day before Easter Sunday, and then deleting it all 5 days later. Everything, the entire case, the reason we're sitting here talking now is because of what the feds say was a 5-day window.
So yeah, what you're referencing here is that, as you say, it's not like the federal authorities say in these filings, RJ is a prolific pedophile, and we have evidence that, goes from 2023 to 2025 or whatever. They allege that there was this 5-day window in which they have these communications, which presumably did not necessarily have to come off of RJ's devices physically. I mean, what we're looking at from these filings are things which would have had to run through Kick's cloud servers, meaning that even if RJ were to scrub all of his devices, they could have worked with Kick, who we're operating under the assumption that they are the ones who provided the tip.
That
which
is correct, yeah.
This is so Kick clearly had some evidence of this conduct, which is what led to the reporting of the tip. And this appears to be the evidence which is being relied upon, because you spoke earlier in this segment about the large number of devices and storage that was taken from RJ's house. And obviously his work as a campaign consultant, a huge part of what you're doing is producing media for people.
Of course.
So you're going to have a lot of SD cards and hard drives, just like I do, producing this show. I mean, I've got like 16 terabytes of hard drives that I carry around with me everywhere, and like more money than I would care to admit worth of
we've
SD
got
cards.
4 SD cards involved in filming this segment
currently
right now.
So anybody who's working with media, that's not really strange, but it is certainly strange, as you're kind of alluding to here, that this is somebody who's an alleged prolific pedophile who, on all these storage devices, they note that they didn't find CSAM.
Which, going back to your question, was his attorney's primary defense. Not only did Special Agent Lorenzen testify that there was no CSAM found on the devices during cross-examination, he made sure to hammer that home. No CSAM was found across 30-plus storage devices. Unfortunately for Phillips, his cross-examination backfired, or at least I believe so, when Agent Lorenzen pivoted to the forensic interview of RJ's child. It's worth noting the forensic analysis of RJ's Samsung, which is where the feds accuse him of downloading Kick and sending child rape videos. All right, it's bad. This is the worst possible stuff. This is as bad as it can get. All right, no amount of adjectives can prepare somebody for the contents of that 22-page motion calling for his detention. It is the worst court filing I've ever read. That being said, in that forensic analysis of RJ's Samsung, the special agent noted that while naked photos were found of at least one of his children, they did not give the impression of being CSAM material, and a further review by Nick Meck confirmed that it was not used, these photos, to engage in any kind of criminality
And for folks that
online.
aren't, working on reporting on a couple of cases like this over the
Hmm.
years, Nick Mack, which you reference here, which is kind of the central, across the whole country organization,
Hmm.
they deal with people putting pornography with children
Hmm.
on the internet, and they're kind of the hub which has this database that authorities of multiple jurisdictions can send something to them and say, is this something that you guys have seen on any of these websites before? So it's significant when they submit these pictures to them and they say,
Right.
we don't see this coming up anywhere online, because it means that this is likely not stuff which has been shared, or if it
Hmm.
has been, it has not yet been caught by authorities as something they need to keep their eyes on.
And I'll correct myself because I've just been so bogged down on this disgusting story that I'm just getting used to the acronyms myself. It's the National Institute for Missing and Exploited Children,
Right.
which were as well the people who handled the cyber tip from Kick, which was eventually referred and later handed over to the Department of Homeland Security. So now that we've got it out of the way, that while there were naked photographs of RJ's children found on his phone, did not believe to be engaged in any criminality, we get to the forensic interview of RJ's son. According to Special Agent Lorenzen, they asked him multiple times during a single interview about being photographed. The child first said that he didn't want to talk about being photographed. When they circled back, he said he can't talk about being photographed. And when they circled back a third and final time, it's my understanding that is when he started to strike himself and eventually retrieved a piece of scotch tape and sealed his mouth shut with it. That is when the forensic interview of RJ's child stopped.
This is the kind of thing where at a hearing to determine whether or not you will be held in the custody of the state prior to your trial, they're not determining your guilt or innocence. But if this is something that they would like to bring up when they prosecute RJ, obviously they could call him to the stand. And,
Mm-hmm.
this would be very painful for him, but they would have to have the state come in and ask him questions, and the defense would cross examine. So this is something that we can see come up again. But I guess the important thing to remember here is legally, to determine that something is what is in federal statute currently called child pornography, which is something, in the media now they're
Mm-hmm.
telling us all to call it child sexual abuse material. That's a whole debate. But currently in the statute, to be child pornography, it has to be something that is clearly of sexual intent. And this is important. Our laws in this country are structured so that people who are not guilty don't get convicted. And if you look at the statutes here, something has to clearly be sexual intent for it to fall in that
Mm-hmm.
category. And you could have a situation where they look at the image and they go, okay, this is not something that is statutorily uh, it's child sexual abuse material. But then you ask the subject about the circumstance in which the photos were taken. And clearly there's, if this testimony was true, some bad memories coming up associated with that.
Right.
So this is very damning stuff. But you also dug in this week. Obviously, we to this point kind of talked about the background of the case, what
Mm.
you heard in court last week.
What are behind the charges? All right, the 10 charges relating to distribution of child sexual abuse material. That's what we've dug into.
Now, there was also kind of this other avenue which they got into on the decision, and I think that this is brought up because flight risk is always something that comes up when they're discussing whether to give somebody a bond. They're going to weigh their danger to the community
Mm-hmm.
and their risk of not coming back for their future court dates. Those are the two big factors. Obviously,
Right.
depending on the state, depending on whether it's federal court or state court, exactly how they weigh it is going to be different. But it's those two big factors they consider.
Mm-hmm.
And so I think that they were talking about, exactly what we just spoke about with his own children as the risk to the community, risk
His
to the
own
people
home.
closest to him. If he were to stay in his home or even, maybe with his parents or something prior to trial. But then you've got the risk of flight. And I think that's why they got into this other alias, which they allege that RJ used, which is Eric Rentling. This is a Facebook page which they say was tied to RJ. And most of the stuff in these indictments, obviously, is evidence which they've collected, which there's no way for us as members of the media or anybody just looking at publicly available information to verify any of this stuff. I mean, they say this device with, this identity code pinged this IP address at this time.
And we go, yes, sir.
And, we have to take them at their word, and that's fine. We're not here to adjudicate the case in the media. We're here to report what is happening in courts of law. And obviously, when it comes time for this case to be adjudicated, they can get into the veracity of that information, and RJ's defense can try to tear that stuff apart and look into it. But what we can look into in these documents which they filed is this Facebook page, because Facebook is public and the internet is forever. And
the page hasn't been taken down.
And the page is still even public if anybody wants to go up and look at this Eric Rentling page at the time that we're recording this. But you've dug through, you've archived this, so even if that does go down, there's still going to be a lot of information for us to dig through. But this, the interesting thing, we even talked about this last week in the show, was that federal authorities were talking about the header, the profile image of this being a picture of RJ from behind. And I think that, you started looking into this, and then you started finding a whole host of questions. So why don't you just start going down the Eric Rentling rabbit hole?
With no intention than to fact check, right? I'm by no means an attorney. I'm not seeking to defend or bury. I just want to understand what's happening here. Of course, I'm going to hear out all sides, whether it be the conspiracy side or the whatever the hell is happening here side. According to the feds, and giving some background on Eric Rentling, during the forensic search of RJ's Samsung, they found an app, Mega, which is a file sharing, an encrypted foreign file sharing app. They noted that the app, deleted the same time as Kik, 5 days after this CSAM deluge, was registered to an Eric Rentling. Further examination of the phone, to my understanding, uncovered a Facebook page designated Eric Rentling. Further forensic examination determined that during this 5-day stint of sharing hundreds of CSAM videos, RJ purportedly logs out of his public Facebook and into Eric Rentling to message with what appears to be Colombian sex workers in South America, specifically inquiring about one girl's age, asking for photos. Eric Rentling, being the element of the federal case that rises it to an international level, according to DHS, warranted federal agents going to Medellin in Colombia and Bogota to identify potential victims, since, according to the feds, videos of RJ engaged in sexual activities with Colombian prostitutes was found on his Lenovo laptop. And the nexus to those international trips was this Facebook page. In open court, Special Agent Lorenzen testified more than once with confidence that Eric Rentling's profile picture appeared to be the back of RJ's head. And upon cross-examination by Phillips, went on to say, look at his hands, look at the broad shoulders, look at the color of the hair. Now, of course, May's attorney argued the relevance of this photo, noting that to the special agent's own testimony, no metadata was found in the photo, and that there is no connection between this entire alias, the alleged alias, and the charges that May is currently facing. There is no connection.
I think it would have to solely be for the flight risk, because as you say, none of the charges pertain to this,
none of the charges pertain to this
side.
So, once I got back to the office, I had this novel idea of reverse image searching the photo that caused so much heartburn in federal court.
And for folks who don't know, reverse image search, you literally just drag the image file into Google Images, and then it will see if there's other instances of the same photo on the internet anywhere.
It's a free service. You could do it on your phone. FITSNews determined beyond a reasonable doubt that is not RJ May. We performed a reverse image search that took about 3 seconds and found that that photo belongs to a royalty-free photo sharing application that's been used in vlogs, within mood boards, on social media for some 6 years and counting now.
This image appears widely across the internet, multiple places.
Multiple places. News outlets, again, on Twitter. This is a royalty-free photo that anyone can download.
And the fact that this wasn't brought up in court means that both the prosecution and the defense didn't know this.
They did not perform the millisecond Google reverse image search that it takes. Instead, going on to say in a federal filing about that photo, the photo associated with this Facebook account appears to be a picture of the back of May's head.
And that's the crucial, they're not lying under oath. Appears to be. It does appear to be the back of May's head. But that makes you wonder, are they, to me, if I'm going to accuse somebody of something that heinous, I'm dotting my I's and crossing my T's. And that's certainly
right.
A strange thing to not get the details right on, because that's pretty important.
And let's talk about some more important factors about this Eric Rentling page. So after determining that that was not RJ May, again, a major point of contention in federal court last Thursday, I decided to reverse image search a number of images on this page. You see, the page, earliest post dates back, I believe, don't quote me on this, to June 6th of 2022. And from there, this Eric Rentling posts about essentially, who's in Cali, not the state, the city in Colombia. Who's in Cali this weekend? Who wants money for Christmas? Hot tubs or balconies? It's a party on Eric Rentling's page, no doubt. Also worth noting, too, that there are a number of women engaging with these posts, like not just 1 or 2 likes, 17 likes, 30 likes, all from women whose pages that we have checked out. And we're talking scantily clad, but clearly developed. Multiple body tattoos, large body tattoos, posing with alcohol, as well as like active posts, active social media posts in lingerie or no clothes at all.
They're selling themselves on Facebook.
They're selling themselves. I'm trying to be
Right.
politically correct here. But that's another important note, because remember when I said that DHS went down to Colombia to identify the potential victims, and they came back, they returned to the States with no identification, yet in 1 week's time, I'm able to build family trees for some of the women engaging with Eric Rentling's Facebook pages. Nonetheless, going back to the images that were shared on this page, his cover photo, which is a beautiful photo of Washington, D.C., reverse image search that belongs to Getty Image, and it's been shared on CNBC, on The Guardian, People, for years as well. The last post on Eric Rentling's page was another advertisement that he was going down to Colombia, who wants to link up, and it looked like an iPhone photo of an airport. Reverse image search that, linked it back to a Forbes article from 4 years ago. So some interesting activity, and the latter of which was not even mentioned in court. They hyper-focused on this photo that appeared to be of RJ, which it's not, and I'm curious to see if any of what we just shared will come up at all. But nonetheless, U.S. Border Patrol, according to the special agent, did confirm that RJ had gone down to Colombia at least 3 times over about a year's period between 2023 and 2024, corroborating the videos found in his Lenovo laptop depicting at least 3 different sexual encounters.
And this is where I think we need to get Andy, A-N-D-Y, at FITSNews.com. If anybody is familiar with, the way that people who purchase sex in other countries go about organizing their meetups. We need to talk to somebody who really understands. Is this a common thing? You know, John is of course the colloquial term for a man who's engaging with
Hmm.
prostitutes. Is this common for Johns who are trying to purchase sex to go on Facebook and to set up profiles like this so that they can easily contact the women? I mean, it wouldn't surprise me. I'm so disconnected from that world, fortunately, that I don't know. But it seems like a fairly logical way to maintain relationships with these people who live on the other side of the country where, you know, you're a
Hmm.
persistent consumer and they're somebody who's going to be engaged in supplying. But I do think you're raising really good questions here about like obviously them going down there and not being able to find any victims. There can be, you can look at it from the perspective of, okay, well, I've, you know, managed to put together this Rolodex of victims here within 12 hours. They probably were able to put together that Rolodex as well. But when you show up to South America as a United States federal law enforcement official, I mean, what prostitute, which meaning a criminal, who's going to talk to federal law enforcement from the United States? I mean, you're probably going to be killed by your pimp for doing so if you live in that world.
Sure, and I'm not going to psychoanalyze that of a South American prostitute, nor am I. I'm neither going to psychoanalyze nor am I going to judge that of the South American prostitute. But the mere fact that again 2 agents were deployed with something in hand that we did not have, and we won't have for a long time in the event this does go to trial, which is chat logs, because all of these
Right.
communications and negotiations appear to have been performed over Facebook Instant Messenger. They had miles of chat logs and hours of video, and they returned with nothing. And then, 10 months after his home is raided, show up to federal court and speak with magnificent authority that a photo appears to be of RJ when a Facebook search when a reverse image search determines beyond a reasonable doubt it's not. It does raise major concern for the integrity of this investigation, which, considering the allegations,
You got to get it right.
you got to get it right.
And you know, the first segment of this show was about a case which I attended on Monday, the Colluci case.
Hmm.
And that's an example of what happens when investigators and prosecutors don't get it right. And this is a case where there certainly is compelling evidence against Michael Colluci, and it remains to be seen whether the Attorney General's office will elect to file charges again. But obviously, the case was quashed by the judge because of errors made in the investigation. And so you can take a case where there's compelling evidence, and by not documenting things properly or by making materially false statements,
Hmm.
you can jeopardize the whole case. So,
And
and
let's just put it on the record. I'm by no means comparing any member of the Department of Homeland Security to the idiot that David Owen is. I mean, how many cases do we? I mean, we're talking off topic here, but how many cases do we need as an example that maybe this is not a fella warranting a Investigator of the Year award?
he was the lead case agent in the Murdoch case who grew to infamy when they testified before the grand jury to get the indictment for Alex Murdoch on murder that he had blood, the blood spatter, you know, presumably from committing the murder on his shirt.
Hmm.
This was, turns out, not blood on his shirt. And there was a very suspicious visit to the
Right.
laboratory, which was across the country in Ohio, that conducted this analysis when they originally got
Hmm.
back the results, which said it was not blood. Then they then got the results that it was blood, and of course, it ended up, you know, by the time it was litigated in trial, oh, it's not blood. There's another case we covered where there was a death of a man who was, it was ruled that he was run over by a train, despite him clearly having truck tracks on his body.
Hmm.
And that's a situation which there is still ongoing litigation, where we hope that there will be some more light shed on that, and we hope to be able to provide our audience with an update on that at some point. But
Hmm.
that's kind of going on in the background right now. But certainly with this particular investigator, we've now seen a number of cases that raise eyebrows.
Which is evidence that not everybody who wears a badge gets it right. I mean, we have a series dedicated to negligent law enforcement officers because, unfortunately for South Carolina, there's many of them. I mean, I don't know how many cases we need to talk about where a lieutenant admits to beating his wife, where a sergeant is caught on camera stealing from the evidence room, or where a sheriff appears to have absconded with federal grade firearms to address a purported pill dependency. I'm talking, of course, about Spartanburg and Chuck Wright. I mean, just because one wears a badge doesn't mean that they are to be trusted implicitly. That is the job of the journalist, the fourth pillar of democracy. We got to hold all these institutions accountable. We can't just take it at face value. We can't
And this
just
is
be
something that you
spoon-fed.
week after week after week hammer. And there's, I kind of thought when we first started working, I was like, is this guy crazy? I mean, he's just hammering these law enforcement
It's
guys
not a
left, right, and center.
popular topic.
But, well, actually, it is if you look at our numbers. But the interesting thing is, and I didn't learn this until, we became acquainted. Tell the folks watching this how traditional mainstream media are directed to treat press releases from law enforcement.
All that the local television station really cares about is getting you to the next commercial break. And they will fill those blocks between the commercial break with whatever crap they need to get you to their sponsors. So the local newsroom is not going to essentially shoot themselves in the foot by holding a local police department, or better yet, a local sheriff's office accountable, because that means they won't get invited to the next press conference where they announce a series of arrests that really don't matter in the grand scheme of things.
And that continues all the way up to the folks who are covering the Pentagon, the folks who are covering the federal government. Yeah, this is why there's this relationship where you talk about the fourth pillar. We're supposed to hold, those in power accountable. Oftentimes, the media just ends up being their PR firm.
Right.
And, that's great for us because that's the reason that we have a business model. We're a couple of idiots with cameras and laptops renting an office. There's no way we should be able to compete with these multi-million-dollar operations and consistently drive more traffic than they do. But the reason that we're able to do that is because we actually are standing here acting as a fourth pillar. And it's uncomfortable to say, look, the federal government has said that this guy is guilty of the most heinous crimes possible, but here's a couple of holes that we can poke in these documents that have been filed. But at the same time, it's important because nobody else, I can guarantee you, at these mainstream media outlets is looking to do that. They're looking to take the United States attorney at his word, and the only way that they will report on flaws in the case, like this Colluci case, is when, for example, the filing which indicated that there was material evidence which was withheld from the defense. We were the first ones to report on it, and we were the only ones to report on it prior to this case being set for retrial this week. So it leaves this big lane open for us, but it's really important. Obviously, we want justice here. We want justice for these victims. We're not, we want that more than anything. But the process has to be done right to get the justice. And I think it's really important. And that's why I'm really glad that you're on this story. When we got this, we're both political guys. We wanted you to handle this story because you don't have that much connection to that world. And also, exactly what you're doing here. I mean, you're a dogged investigative journalist in that you go through the details, you go through the timeline, and you actually care to hold these folks accountable and make sure that they're dotting their I's and crossing their T's. And I think at this point, it's probably premature to say where any of this will go. I mean, maybe they were 95% right about the stuff about Eric Brentling on Facebook, and this reverse image search photo was the one thing they got wrong. But at the same time, I'm glad that you're checking their homework and making sure that there's at least what we can verify is correct.
I want it to make sense. I don't want the federal narrative. I want the truth. And I would hope that that's what Homeland Security wants. I would hope that's what any member of the State House wants. This segment that we just participated in, I feel it hardly scratches the surface of some of the findings through open source intelligence that I incorporated in our sweeping article, Political Ties and Hard Drives, The Fall of R.J. May. We toss to the federal filings that we've cited. We incorporate screenshots, again, from open source intelligence, tips submitted to us from Telegram, screenshots that I've pulled from rudimentary PayPal searches. It's an alarming story. It's a scary story, and it's something that deserves intense media and federal scrutiny. I trust that Homeland Security will keep on doing what they're doing, as will we. So for those interested in holding truth to power and getting the full story out, as we are not bound by corporate overlords or filling time in between commercial breaks, I encourage you, reach out, Andy@FITSNews.com. You'll remain anonymous, your titles will be protected, and we'll keep doing what we've been doing this whole time.
That's what it's all about, man. Holding truth to power. Andy@FITSNews.com. This investigation is far from over. You're still putting together this story here, and whether it's you just want to provide information on background, whether you're somebody who knew any of the people connected with this, if you're the kind of person who has the kind of information that Andrew would find useful. So we'd really appreciate it if you share it. Thank you for watching this week's episode of The Week in Review. Your support is what makes this possible. Here on YouTube, like the video and subscribe to the channel. But also, a lot of you guys have never visited FITSNews.com, and Andrew just referenced the tip of the iceberg. What we're able to talk about in the limited time on this show really is the tip of the iceberg, and it's only a couple of the many stories that we cover every week. If you like this content, as many of you guys do that have never been over to our website, go to www.FITSNews.com. This is a locally owned, independently operated news outlet with all the breaking stories in South Carolina and many stories from beyond. Be sure to check it out and subscribe over there. Those $8 a month are what fund everything you're seeing here. So we'd really appreciate it if you check it out. And also, next week, be sure to tune in live on Friday at 11 on X or on YouTube for the FITSNews Live Month in Review. We're going to be going through all the biggest stories of the month and giving you guys the opportunity to come and interact with us and ask the questions that you might have about these stories and hear our answers in real time. So once again, next Friday at 11 a.m. Eastern, tune in.